Welcome back to the Deep Dive. We're here again, ready to help you navigate some complex material.
And our goal, as always, is to extract those crucial insights directly from the source material you're working with.
Exactly. Think of this as, well, a focused exploration, getting you right to the core information, maybe with a few interesting details thrown in.
And today's deep dive is into a really significant area, Islamic civil law. We're focusing specifically on contracts and torts.
That's right. And we need to state right at the beginning something the sources emphasize. The material we're drawing on today has been made available by the University of London purely for educational purposes.
Absolutely. And this deep dive itself is brought to you by Sinorbit Academy, Sri Lanka, also with a purely educational aim.
Yes, it's specifically designed to help you, our listeners, prepare for your upcoming exams on this very topic.
So we really hope this is useful for your revision. We know how important these exams are, and we genuinely wish you the very best of luck with your preparation.
Definitely. Good luck, everyone. Okay, so let's dive in. Islamic civil law, particularly contract law. You really need to understand the context, don't you?
You really do. The sources remind us that trade was, well, it wasn't just important in early Islamic society, it was absolutely central.
Prophet Muhammad himself, being a merchant before his prophethood, that's a key point the material highlights.
Exactly. And that deep-rooted commercial background meant that pretty early on, quite sophisticated legal rules developed around trade, especially for contracts.
And the foundation for all of this, it comes straight from the Quran, the primary source.
Yes, and two principles just jump out immediately, shaping everything else. First, trade itself is fundamentally lawful, even encouraged. But second, there's this sharp contrast with the strict prohibition of usury, which is known as riba.
And also excessive risk or uncertainty.
Right, gharar. That's the other big prohibition. So lawful trade versus prohibited riba and gharar. That's the starting point.
And this isn't just implied, is it? The Quran is explicit.
Very explicit. The sources point us to Surah 2, verses 275 to 279. And the key phrase there is, Allah has made trading lawful and has made usury unlawful.
Wow, well, that's pretty direct.
It is. It's a fundamental boundary set right in the primary text. No ambiguity about the prohibition of usury.
Now, this ethical and legal framework for contracts, it seems quite different from how the law approached, say, harm caused to others, torts.
Yes, the development was different. Contract law became this quite distinct area focused on agreements. But the traditional law of torts dealing with wrongs, compensation for harm, it wasn't always so separate as a civil sphere.
So where did it fit?
Often, as the sources note, it was largely integrated within Islamic criminal law. We'll get into that more later.
Okay, so our mission for this deep dive, based on the material you have.
Well, we're going to unpack these two big areas systematically. We'll kick off with Islamic contract law. We'll look at the basic principles, who has the capacity to make contracts, some specific types like murabaha, which is super relevant today.
Especially in finance, right?
Exactly. And also concepts like preemption, gifts. Then we'll switch over to the law of torts. We'll look at its traditional characteristics, its limitations, and importantly, how it's evolved in modern legal systems.
And the goal isn't just listing rules, is it? It's about understanding the why.
Precisely. Understanding the principles, the context, the modern relevance, and those key distinctions. We'll make sure to highlight and, repeat important terms and concepts, things you'll definitely need for your exams.
Sounds good. And we'll follow the structure in the source material, starting with contracts.
Makes sense. Logical flow.
Okay, let's unpack this. Diving straight into the world of Islamic contract law as presented in your sources. And it starts with an interesting comparison. Unlike some systems, Islamic law doesn't seem to have this single grand theory of contract, does it?
That's right. The material points out it's more like Roman law in that respect. Instead of one abstract theory, it recognizes a set of specific named contract types. They're often called nominate contracts.
Like sale or lease or gift?
Exactly. Bay for sale, ijara for lease, hibah for gift, hire contracts, each with its own defined structure and rules.
But even without that single overarching theory, there must be some general principles that apply across the board to all contracts.
Oh, absolutely. There are fundamental requirements for any valid agreement. And the most basic one, the real cornerstone, is offer and acceptance.
Right, the classic meeting of minds.
Precisely. A contract is generally formed when an offer, which is ijab in Arabic, is met by an acceptance, qabul. You need that ijab wa qabul being. It's fundamental.
Okay, ijab wa qabul. Offer and acceptance. And for that to be valid, the sources mention specific conditions.
Yes, a couple of key ones. First, both the offer and the acceptance have to come from parties who are legally competent. We'll dig into capacity in detail soon, but basically they need the legal standing to agree.
Makes sense. And the second?
This one's quite distinctive. Generally, the offer and acceptance must happen in the same meeting or session. The term for this is modules.
Modules. So the place or the time where the deal is actually struck.
Sort of, yeah. It signifies the session where the parties are present, negotiating and concluding the contract. It creates that direct contractual link.
So competent parties, ijabah kabul, within the same majlis. What happens once those are met?
Well, generally, the contract takes effect immediately, and this ties into another principle the sources highlight. Islamic law isn't keen on contracts in futuro.
In futuro. So contracts that depend on some future uncertain event.
Exactly. Agreements where the effect is suspended until something uncertain happens later. Why the dislike?
Let me guess. It relates back to that prohibition. Gharar.
You got it. Excessive risk or uncertainty. Contracts depending on uncertain future outcomes. They often involve too much gharar. The law prefers certainty, immediate effect, things being clear up front.
Now, this is really interesting. There's this principle, right, that Muslims must abide by their obligations. Kind of like pacta sunt servanda.
Yes, based on Surah 5, verse 1. That principle is central, but, and this is a big but, the sources stress it's not about absolute freedom of contract.
Ah, so there are limits, ethical limits.
Huge ethical limits. The ethical dimension is paramount. And one of the biggest limitations is the principle against unjust enrichment.
Unjust enrichment, meaning you shouldn't profit unfairly.
Essentially, yes. The core idea is you shouldn't get a monetary advantage without giving something of countervalue in return. Profit should be linked to effort or risk you genuinely take or transferring ownership of something, not just gained through exploitation or, the mere passage of time without risk.
The sources give examples of this, right? What counts as unjust enrichment?
Yes, the most obvious one, of course, is charging excessive interest riba. But it also includes things like, say, you hire something, and then you immediately re-let it to someone else for a higher price without adding any value yourself.
Okay.
Or you buy something, agree on a price, but before you've even paid the original seller, you resell it to someone else for more. In those cases, the gain isn't really tied to your effort or risk in the same way. It looks more like profiting from a loophole or just your position. Islamic law views that kind of gain suspiciously.
Right. It needs to be earned through genuine economic activity, not just clever maneuvering without substance.
That's a good way to put it.
So let's really dig into those two big prohibitions again, because they seem absolutely fundamental. Riba and gharar.
Definitely the two most significant fences around commercial dealings. Riba, as we said, is usury or interest, technically defined as exchanging money for money where there's an excess paid back tied to a delay.
And the sources are clear. This is universally prohibited.
Absolutely universal. All schools of Islamic law agree on this. It's not debated. It goes straight back to that Quranic verse we mentioned, Surah 2.275-279, where Allah explicitly distinguishes lawful trade from unlawful riba. The ban on interest-based loans is one of the strictest aspects.
Okay, so riba is clear. What about gharar again? Excessive risk or uncertainty?
Yes. And it's not all uncertainty business always has risk. It's about excessive or unnecessary uncertainty, often about the actual subject matter of the contract or its outcome.
The source gave that example about the dates, didn't it?
Yes, the classic example. You can't sell dates still unripe on the tree, promising to deliver them when they ripen. Why not? Because the ripening itself is uncertain. Will they all ripen? What quality will they be? When? Exactly. That level of uncertainty about the core subject matter introduces too much gharar.
Makes sense. It's too speculative.
Exactly. And the sources note gambling is banned for a similar reason. The outcome is pure chance, inherent uncertainty. Although it's interesting.
What's that?
Well, the material mentions that some modern civil codes in Muslim-majority countries, like Jordan, allowing gambling on racecourses, show how legal systems sometimes adapt or carve out exceptions. It highlights that tension between traditional principles and modern pressures or interpretations.
Fascinating. And understanding riba and gharar is vital for grasping modern Islamic finance, right?
Absolutely crucial. Because financial products designed to be Sharia compliant have to avoid these. That's why you see structures based on trade, like murabaha, or partnership, like mudaraba and musharaka, instead of conventional loans. They're specifically engineered around these prohibitions.
So these aren't just historical rules. They're actively shaping global finance today.
Very much so. Living principles with huge practical impact.
Okay, we've got the foundations, the big prohibitions. Let's get more specific now. Who can actually make these contracts? Let's talk capacity.
Right, capacity. Because as we said with ijab or kabul, you need competent parties. In Islamic law, for general contracts dealing with property and commerce, setting aside marriage, for now, the main threshold is reaching puberty.
And that applies equally to males and females.
Generally, yes. Puberty marks the attainment of full contractual capacity.
Are there clear age markers for this?
Yes, the sources give us some presumptions, irrebuttable ones. For boys, below age 12, it's presumed they haven't hit majority and no full capacity. For girls, that lower age is 9.
So below 12 for males, below 9 for females, definitely no full capacity.
Correct. And at the other end, by age 15, for both boys and girls, it's irrebuttably presumed they are adults and do have full capacity.
What about the gray area in between? Between 9 and 15 for girls, 12 and 15 for boys?
In that window, whether someone has reached majority and gained full capacity is a question of fact. It depends on whether the actual physical signs of puberty have appeared. If they appear before 15, capacity is attained then. If not, it defaults to age 15.
And what happens to the property of children who haven't reached that full capacity yet?
It's managed by a guardian. The sources lay out a clear hierarchy for who this guardian should be. The father is first in line.
Okay.
If the father isn't there, it's the person the father appointed. If no one was appointed, it falls to the nearest male relatives following the order of inheritance.
And the guardian's role?
It's a fiduciary duty. They act as a trustee, must safeguard the child's interests, manage the property equitably.
Now, the sources also talk about a sort of limited capacity. For children past a certain age, but not yet fully adult.
Yes, the age of discernment. This is usually considered age 7. From 7 onwards, a child has what's called restricted contractual capacity.
Meaning they can do some things.
Exactly. They can validly enter contracts that are clearly, manifestly to their advantage. The classic example is accepting a gift. That's obviously beneficial, so they can do that on their own.
But they can't do things that are clearly disadvantageous.
Right, like making a gift themselves, giving something away for nothing. That's manifestly contrary to their advantage.
What about contracts in the middle? Neither obviously good nor obviously bad.
Those contracts, if entered into by a child with restricted capacity, aren't automatically void. They're considered suspended. Their legal status hangs in the balance until the guardian weighs in. The guardian can either approve, ratify it, or reject, repudiate it.
Can this guardianship, this lack of full capacity, ever extend beyond the age of majority?
Yes, in certain situations, the sources mention that with judicial permission, guardianship or interdiction can continue for adults who are deemed unable to manage their own affairs.
That's just...
People who are insane or feeble-minded, even if not formally certified. Also, spendthrifts, people known to waste their property, or those considered easily deceived. The court steps in to protect their assets.
And there's also a link to death sickness.
Yes, briefly mentioned again here. During a final illness, a person's capacity, especially for giving things away like gifts, becomes restricted. This ties into succession law. The 1/3 limit we'll discuss more under gifts. It prevents someone from unfairly distributing their property just before death.
Okay. Now, this leads us to a specific area of capacity that the sources flag as having different interpretations. The capacity of women, especially under the Maliki school.
Yes, this is an important point of discussion in the materials. There's a perception noted that under the Maliki view, women might not get full capacity right at puberty, that married women might need their husband's okay for contracts, and specifically, after marriage consummation, their ability to make gifts or charitable donations might be capped at 1/3 of their property.
And the UAE law reference.
The UAE Commercial Transactions Law, Article 21(2), about a foreign wife needing her husband's consent to trade, is cited as potentially reflecting this kind of view.
However, the source immediately brings in a counterpoint.
A very strong one. It points to Imam Shafi, a major jurist who actually studied directly under Imam Malik. Shafi stated in his work, Al-Um, that the jurists he knew agreed that men and women were legally alike in handling their affairs once they reached puberty and maturity.
Coming from Malik's own student, that's significant. It suggests the idea of generally reduced capacity for women might not have been Malik's original core teaching.
It certainly raises that possibility. It might be a later interpretation or a misunderstanding, and the source looks at what a leading Maliki jurist, Sanun, actually said.
And what was Sanun's view?
Sanun, as presented, held that a married woman does have full capacity for all her civil transactions except for one specific area: charitable dispositions. Her ability to give away property charitably was limited to one-third unless certain conditions were met, often involving the husband's consent or specific needs.
Okay, so a specific limit on charitable gifts, not general contracts. And the reason for that limit.
This is crucial. Sanoon's reasoning wasn't about women lacking intelligence or business sense. It was explicitly linked to the possibility of pregnancy from the marriage and the need to protect the inheritance rights of potential future children. Giving away too much in charity could unfairly diminish what future heirs would receive.
Ah, so it's framed as protecting potential heirs, not as an inherent limitation on the woman's capacity itself.
Exactly. The source suggests this distinction is vital. Is it about capacity, or is it a specific rule tied to marital status and potential offspring aimed at protecting family property rights? Sanoon's explanation points towards the latter.
That's a really important nuance. It challenges a common perception.
It does. And the source also mentioned the practice in Pakistan courts regarding Persian women, those who observe seclusion.
How do the courts approach contracts made by them?
They place a high burden of proof on the other party, the one benefiting from the contract or gift. That party has to prove convincingly that the woman fully understood the transaction and its consequences. It's a protective measure to prevent exploitation, showing how legal principles adapt to social contexts.
And just to wrap up capacity, it's worth remembering.
Yes, that in many modern Muslim countries, the actual legal age of majority for commercial dealings is now often set by civil codes, providing a clear, uniform standard separate from the physical signs of puberty.
Right. Simplifies things in practice.
Definitely.
Okay, let's shift now to a huge topic in modern Islamic finance. Something structured specifically to avoid riba,
Yeah.
the murabaha contract.
Yes, murabaha. It's absolutely central. The sources define it as a type of sale. The seller sells an item for the price they originally paid for it, plus a stated known profit margin.
So cost plus profit sale.
Essentially, yes.
Yeah.
At its core, it's just an ordinary sale contract, but with that specific disclosed profit component.
And the critical point is that it's not a loan.
Absolutely not an interest-bearing loan. That's the whole point of its structure. It's designed as a genuine sale of a tangible good where the payment is deferred, and that deferred price includes the pre-agreed profit. The profit comes from the act of trading the good, not from lending money over time.
For this to be valid under Sharia, to be genuinely different from riba, there are strict conditions, right?
Very strict. Non-negotiable conditions for compliance. First, obviously, it has to meet all the standard requirements of any Islamic contract competent parties, ijab al-qabul, etc.
Okay.
Second, and this is crucial when a bank is involved, the bank, or financing institution, must actually buy the commodity the client wants. They buy it from a third-party supplier in their own name. They become the owner temporarily.
They can't just give the client the money to buy it.
No, that would look too much like a loan. The bank must enter the chain of title. Third, the bank must take possession of that commodity after buying it.
Actual physical possession, like it has to be in their warehouse.
Not necessarily physical. It can be constructive possession. This means the bank has legal control and, most importantly, has accepted the risk associated with the goods, even if they haven't physically moved them yet.
Which leads to the fourth condition.
Exactly. The commodity must be at the bank's risk during the period after the bank buys it and before it sells it on to the client. Even if that period is very short, the bank has to bear the ownership risk.
Okay, those are the specific murabaha conditions, and it also have to follow the general rules of sale.
Yes, the basics still apply. The object being sold must be valid property, malwe, something lawful and with value.
And the seller of the bank, in this case, must actually own the item when they sell it to the client.
Yes, ownership and possession, actual or constructive, are key. The bank needs to hold it long enough to genuinely assume the burdens of ownership before passing it on.
Delivery must be certain. Price must be fixed.
Certain delivery, yes. And the total price, the cost, plus that agreed profit must be clear and fixed at the time the murabaha contract between the bank and the client is signed. No ambiguity later.
And what about defects? If the client discovers something wrong with the item later.
Very important point. The buyer always retains an unconditional right to rescind the contract if they find an intrinsic defect that existed at the time of sale. This right is called khiyar al-ayb. Let's repeat that. Khiyar al-ayb.
Khiyar al-ayb.
Uh-huh.
The right to return defective goods.
Yes. And the sources stress you cannot contract out of this. Any clause trying to make the buyer waive their khiyar al-ayb is void. It's a fundamental buyer protection.
These conditions sound quite strict. Are they followed in practice?
Sharia compliance boards in Islamic banks are generally very strict on these points. The sources mention Nicholas D. Ray and industry bodies like the International Association of Islamic Banks, emphasizing that the bank must have received the goods and accepted risk before selling to the client. It's not just paperwork.
And there was a major court case confirming this.
Yes, a really significant one highlighted in the material. M. Aslam Kaki v. Muhammad Hashim. This was a decision by the Supreme Court of Pakistan in the year 2000. Let's say that again. M. Aslam Kaki v. Muhammad Hashim, PLD 2000 SC 225.
Aslam Kaki. What did the court say?
The court essentially laid down the law on what constitutes a valid murabaha in the modern context. They held firmly that murabaha is fundamentally a sale. It's not financing in its origin. Therefore, it absolutely must comply with all the essential requirements of a sale contract under Islamic law.
And it's only allowed when?
Only when the client has a genuine intention to actually purchase a specific commodity. The bank then acts as an intermediary seller, fulfilling its role by genuinely purchasing the item, taking ownership and possession, physical or constructive.
And critically?
And critically, as Justice Maulana Muhammad Taqi Usmani emphasized in the judgment, the bank must assume the risk associated with the commodity while it's in their ownership. He called this risk transfer the basic feature, distinguishing murabaha from an interest-based loan.
So ignoring that risk transfer element essentially turns it back into a prohibited loan.
That was precisely his warning. If the risk aspect is treated as a mere formality, the whole transaction loses its Sharia legitimacy and becomes functionally identical to lending on interest.
Wow. So that period where the bank holds the risk, however brief, is the absolute core difference.
It's arguably the single most important difference. It signifies genuine participation in trade, not just passive lending. The bank, like any merchant, faces potential loss if something happens to the goods before the final sale.
And that's why banks often get insurance for that specific interval.
Exactly. It's a practical consequence of bearing that real commercial risk.
Okay, makes sense. So if the client buys, say, a machine using murabaha, the bank buys it from the supplier first. For a moment, it's the bank's machine at the bank's risk. Then the bank sells it to the client at the agreed cost plus profit deferred price.
That's the required flow. If the machine is damaged before that final sale and delivery to the client, the loss falls on the bank, not the client.
Understood. Now, what if the client pays late? Banks can't charge interest penalties.
Correct. Liquidated damages based on a percentage of the debt accruing daily or annually. Strictly forbidden. That's riba. However, modern practice allows something else. The parties can agree upfront in the contract on a higher predetermined price if the payment is made after a specific due date. So it's like price X if paid by date Y, price X plus Z if paid after date Y. The price differential is fixed and agreed from the start, not an accumulating penalty.
Subtle difference, but legally crucial. It's part of the agreed sale price structure, not a separate interest charge.
Exactly. The sources also briefly mention other prohibitions, like exchanging one obligation for another uncertain future, one that brings in gharar again, and avoiding unnecessary delays in exchanging counter values where simultaneous exchange is required, like in currency deals.
And a murabaha isn't the only tool, right? You mentioned others.
Yes, the sources touch on mudaraba and musharaka. Mudaraba is like a silent partnership. One party provides capital, the other provides expertise labor, and they share profits. Musharaka is more like a joint venture. Both parties contribute capital and effort, sharing profits and losses according to agreement.
These are based more on partnership and risk sharing.
Yes, many scholars see them as embodying the risk-sharing principle even more deeply than murabaha, which remains fundamentally a sale transaction.
Okay, great overview of murabaha and related concepts. Let's shift focus slightly to a specific right related to property sales. Preemption. Shufa.
Shufa, yes. This is a third party's right to essentially step into the buyer's place when real property is sold. They can force the sale to themselves by paying the same price the original buyer agreed to pay.
A right of first refusal, almost, but after the deal is struck.
Kind of, yes. It allows certain people to acquire the property preferentially.
Who gets this right? When does Shufa arise?
The sources mention a few key scenarios. Very commonly, if property is jointly owned and one co-owner sells their share to an outsider, the other co-owners have the right to preempt and buy that share themselves.
Okay, that makes sense. Keeps property within the existing group.
Also, someone who jointly owns an easement attached to the property, like a shared right-of-way, might have the right, and importantly, under the Hanafi school of law.
Yes.
The right of shufa is also given to the owner of the immediately adjacent property. The neighbor gets first dibs, so to speak.
The neighbor. That's interesting. Is that rule still around?
Yes, the sources note this Hanafi neighbor rule is actually preserved in some modern legal codes like Egypt's civil code,
Huh?
but there's a twist.
Ah, the legal workaround you mentioned earlier.
Exactly. The sources describe this fascinating legal device, a hayal or legal stratagem, used historically, especially under Hanafi law, to get around the neighbor's preemption right.
How'd it work?
Let's say the seller wants to sell to buyer X, but neighbor Y has the right of preemption. The seller would first gift a tiny, insignificant strip of their land, right next to neighbor Y's property, to buyer
Oh,
X.
gift. Okay.
Immediately after that gift is complete, the seller then sells the rest of the property to buyer X.
Why does gifting that tiny strip defeat neighbor Y's right?
Because the right of shufa arises only from a sale, not a gift. By gifting that strip first, buyer X becomes the new adjacent neighbor to the main piece of land being sold. Neighbor Y is now only adjacent to the tiny gifted strip, which wasn't sold. When the main property is then sold to buyer X, neighbor Y no longer has the preemption right over it because the buyer is now the adjacent owner.
That is clever. It uses the rules about gifts versus sales strategically.
It's a classic example of how legal rules were navigated in practice.
So if someone does have the right of shufa and wants to use it, how do they go about it?
Speed is essential. The sources say they must declare their intention to exercise the right immediately upon learning of the sale. Any delay can mean losing the right. And they need to follow proper formalities, often involving witnesses, to make their claim legally solid.
Got it. Immediacy and formality are key for shufa. Now let's look at another way property changes hands. Gifts or haiba.
Haiba, yes, this is transferring property purely gratuitously, with nothing given in return. The general rule is that any sane Muslim who has reached majority can gift away their property during their lifetime.
Subject to that potential Maliki qualification we discussed earlier.
Yes, remembering the nuance about the possible one-third limit on charitable dispositions by married women under the Maliki view, which, as Sanun explained, was aimed at protecting future heirs.
So what makes a gift a valid haiba? What are the requirements?
3 key things. 1, the transfer must be immediate. It's not a promise for the future. It happens now. 2, it has to be accepted by the recipient, the donee, or someone on their behalf. 3, absolutely nothing can be given in exchange. If there's counter value, it's not a gift, it's a sale or barter. Repeat those. Haiba means immediate transfer, acceptance, and no exchange.
Is there agreement on when the gift is legally done?
There's a slight difference between the schools here. Most schools, Hanafi, Shafi, Hanbali, say the gift is only complete and binding once there's been both acceptance and the actual transfer of possession, the handing over.
But the Malikis differ.
Yes, the Maliki view as presented is that the gift is considered complete based on the declaration and acceptance even before the physical handover occurs.
Interesting difference. But regardless of that timing, there's one principle that's essential across the board.
Absolutely essential for validity. The donor must completely divest themselves of ownership and control. They have to genuinely give up the property. If they try to keep using it, benefiting from it, or controlling it after supposedly gifting it, the haiba is likely invalid.
Ensures it's a real transfer, not just on paper.
Precisely. It proves the sincerity and finality of the act.
And connecting back again, gifts made during death sickness.
Right, the rules tighten up then. As we touched on, such gifts are restricted mainly to protect heirs' rights under inheritance law. The gift can exceed 1/3 of the donor's total estate after deaths.
And what if the gift is to an heir?
A deathbed gift to someone who is already an heir is generally invalid unless all the other heirs agree to it after the donor has passed away. This prevents someone from using last-minute gifts to bypass the fixed inheritance shares and favor one heir over others.
So it really balances the right to give during life with the compulsory inheritance rules that apply after death, especially when death seems imminent.
Exactly. Succession principles limit lifetime dispositions in that specific context.
Okay. And just briefly looping back to the modern world, it's clear how these principles we've discussed, lawful trade, no riba, no garar, plus tools like partnership, mudaraba musharka, and sales structures like mubaha, are the building blocks for today's Islamic finance industry.
They absolutely are. They provide the legal and ethical framework driving product development and innovation in that massive global sector.
Right. Now let's move from obligations arising from agreement, contracts, to obligations arising involuntarily from causing harm, The law of torts. The sources suggest this area developed differently.
Quite differently, yes. As we hinted earlier, traditional Islamic law didn't really develop torts as a completely separate, comprehensive body of civil rules like it did for contracts. It overlaps significantly with criminal law.
So, remedies for harm existed, but maybe within a different framework.
Exactly. The sources mention offenses under PISAs, retaliation for physical harm, or those leading to dia, fixed monetary compensation, sometimes called blood money. These are often seen as criminal penalties, but they also function to provide a form of redress or compensation to the victim or their family, similar in outcome to tort damages in some ways.
So, no separate civil code of torts, but a principle against causing harm.
Oh, the principle itself is fundamental. It's derived from a very famous prophetic saying, a hadith. There is no darar harm or dirar prejudice in Islam. Let's repeat that. No darar or dirar. It establishes a clear moral and legal baseline. Wrongfully harming others is prohibited.
Okay, harm is prohibited. But what about compensation when harm does occur? How did traditional law approach that?
Traditionally, as the sources explain, compensation was quite limited compared to many modern systems. It was typically available only for actual damage.
Meaning tangible, measurable loss.
Yes. Physical injury, damage to property, direct financial losses that you could quantify and prove.
Which leads to a really key limitation mentioned in the sources.
Yes. Traditionally, under classical Islamic law, damages were generally not awarded for what we'd call moral damage,
Things like,
like damage to reputation from defamation, emotional distress, or compensation solely for the pain and suffering caused by an injury. The focus was squarely on the tangible, material loss.
that's a major difference from, say, modern Western tort law, where non-economic damages like pain and suffering could be substantial. Any idea why the traditional focus was so narrow?
The sources don't delve deep into the philosophy, but it likely reflects a system prioritizing restitution for direct, measurable harm. Perhaps it was seen as difficult to objectively quantify subjective suffering within that legal framework, or maybe the focus was more on the fixed compensation amounts, dia, for specific physical injuries rather than individualized assessments of suffering.
But this traditional view isn't the end of the story, is it? Modern laws have changed.
Dramatically, in many places. The sources explicitly state that many modern civil codes in Muslim-majority countries do now allow for compensation for moral damages, including pain and suffering. This shows a clear evolution, adopting and integrating concepts from other legal traditions to provide broader remedies.
So the historical baseline was actual damage only, but modern practice is often much wider.
Generally, yes.
Right.
However, there's an exception noted.
Saudi Arabia.
Yes. The sources highlight Saudi Arabia as a jurisdiction where courts applying traditional principles have historically continued to refuse compensation, not just for moral damages, but also for future loss.
Future loss, like lost earnings potential after a disabling injury.
Exactly. Under that traditional application, compensation might cover medical bills and lost wages up to the trial date, but not the pain itself, nor the projected inability to earn income for years to come. Compensation is limited to quantifiable loss already incurred.
That seems very restrictive. Is that the whole picture in Saudi Arabia, though?
It's complex, because while the traditional courts might apply those limits, the sources point out that specific regulations exist in Saudi Arabia that do provide for broader compensation, potentially including moral damages or future loss in certain contexts, like workplace injuries.
But who awards that compensation?
Only the specific designated tribunal or court empowered to enforce that particular regulation. So the labor court might award pain and suffering under the labor regulations, but a general court applying traditional tort principles in a different type of case might not.
Okay, so it's a mixed system. Traditional principles in general courts, but specific, potentially broader remedies available through specialized tribunals enforcing modern regulation.
Precisely. It shows how legal systems can layer traditional and modern approaches, with the specific forum becoming critical.
Right, that makes sense. So let's try to pull all of this together. We've covered a huge amount, drawing from your source material from the foundations of contract law, riba, gharar, through capacity rules, the details of murabaha, including that key M. Aslam Kaki case, property rights like shufa and haiba, and finally the distinct traditional approach to torts and its modern evolution.
And hopefully we've hit the key learning outcomes the sources were aiming for, understanding those capacity rules, the defining features of murabaha and similar contracts, how gifts work, the role of preemption, and the specific limitations around traditional tort liability.
And we can see the connections, right? Capacity affects who can make a murabaha or a haiba. Riba and Garar rules dictate why Murabbaha is structured the way it is. Gift rules overlap with succession law. Shufa is specific to real property sales. Torts arise from harm, distinct from voluntary contractual obligations.
Absolutely. Now, thinking about your exams, let's use those sample questions from the source material to see how you might apply this. Question 1. Ahmad wants to sell his field, neighbor wants it, but Ahmad prefers his son-in-law. What's the advice?
Okay, alarm bells should ring. Neighbor, field sale. This is about preemption, Shufa. You need to explain the neighbor's potential right, especially under Hanafi law, adjacent owner. Mentioning it might still exist in modern codes like Egypt's. Repeat the term, Shufa.
But the crucial part is advising Ahmad. You must discuss the legal workaround that hayal. Explain the tactic. Gift a tiny strip adjacent to the neighbor to the son-in-law first, then sell the rest to the son-in-law.
And explain why it works.
Yes.
Shufa applies to sales, not gifts. Gifting the strip makes the son-in-law the new adjacent neighbor before the main sale happens, defeating the original neighbor's claim. You need both the rule and the workaround.
Perfect. Now, question 2. Discuss the statement, Muslims acquire the right to deal with their property once they have attained puberty. This opens the door to everything about capacity.
Right. Start with the general rule. Puberty. Explain the age presumptions. Below 129 by 15, the question of fact, period in between.
Then, crucially, discuss the situation before full majority. Restricted capacity from age 7, age of discernment. Detail what they can do, accept gifts manifestly advantageous, what they can't do, make gifts manifestly disadvantageous, and what's suspended pending guardian consent, other contracts.
Don't forget the exceptions allowing interdiction beyond majority, insane, spendthrift, etc. And you absolutely must address the nuances regarding women's capacity.
Yes. Outline the perceived Maliki view, then present the strong counter-evidence from Shafi, and detail Sundin's more precise position, the 13 limit on charitable gifts by married women, and importantly, the reason, protecting potential heirs. Adding the Pakistan court's approach to partisan women shows practical application and awareness.
So for exam answers, it's about explaining the rules, the exceptions, the reasoning, different views, and practical applications or workarounds. Use this deep dive as a guide, but definitely revisit the source material from the University of London. Review your notes.
And focus on the why. Why is riba prohibited? Why the Garar rule? Why the 13 limit on deathbed gifts? Understanding the underlying principles helps you remember and apply the rules correctly. Define your terms. Aslam kaki, shufa, hiba, kiara libet, riba garar. Show you grasp the details.
Okay, so wrapping up this deep dive, we've aimed to give you a detailed, structured walkthrough of these key areas of Islamic civil law, based directly on your source material, hitting the main rules, principles, and distinctions relevant for your studies.
We hope it's been valuable. Remember, this deep dive was brought to you by Sinorbit Academy, Sri Lanka, purely for educational purposes, using University of London materials.
As you continue preparing for your exams, here's a final thought to ponder, building on our discussion. Given Islamic civil law's historical roots in trade and its strong ethical constraints against things like riba and garar, favoring risk-sharing and genuine economic activity, how might these foundational principles continue to shape and perhaps challenge the evolution of commercial law and financial practices in the Muslim world as it engages ever more deeply with global systems, new technologies, and complex financial engineering?
It's a fascinating intersection of tradition and modernity, constantly evolving. Lots to think about there.
Indeed. Thank you for joining us on the deep dive. We sincerely wish you the very best of luck with your upcoming exams. Study well.
Yes, good luck. Keep exploring these important and complex topics.